we occupy in the justice system is to serve the ordinary litigant. It is important to constantly remind ourselves that in everything we do in our professional lives, all our efforts must be geared towards making the lives of ordinary citizens easier. While navigating through the justice system may seem like second nature to us, for the ordinary litigant it is no small ordeal. The intricacies of procedure, the patient wait for one's day in court, and the complex legal doctrine can be overwhelming to even the most sophisticated litigant. In such a setting, it is our collective duty as judges, advocates, court staff, and clerks to assuage the litigants' anxieties and help them comprehend this complex labyrinth with kindness and empathy. On this occasion last year, I spoke at length about the growing pendency in the Honorable Court. The annual increase in the number of cases pending in the apex court of the country painted a rather gloomy picture, especially with respect to efficiency and expediency at the very top tier. Thanks to the efforts of this Honorable Court, as well as my fellow members of the bar, we have been able to reverse this growing number in the last 12 months. In the judicial year that just closed, the pendency of cases has decreased from 60,508 to 57,234. This represents a 5.4% decline. 3,274 cases in numerical terms in the total pendency before this Honorable Court. This is a significant improvement over the previous judicial year 2023 to 2024, when the total pendency grew from 56,544 to 60,508. This was an addition of 3,964 cases, or roughly 7%. In this context, this court has turned a 7% increase in pendency to a 5.4% decrease in pendency, representing a difference of 12.4 percentage points from the previous year's performance. While we all, as actors in the justice system, and particularly the members of this Honorable Court, deserve praise and congratulations on this remarkable performance, we must take a pause to interpret what these numbers mean. More than anything, this decline in pendency indicates that even for the most insurmountable of tasks, small but meaningful inroads can be made by consistent, focused, harmonized, and consolidated efforts. This court in the past year has formed specialized benches to deal with cases relating to various branches of law. In my speech last year, I particularly focused on the perils of delays in the criminal justice system. In the last 1 year, this court and its members have paid particular attention to that. This court's kind attention has provided timely closure to many litigants, accused persons and complainant alike, involved in criminal litigation. While we celebrate this impressive achievement, we must also understand that there is much that still needs to be done in this regard. The court must also now pay attention to other areas of law, especially civil disputes. Civil disputes have been known to take decades to reach their ultimate conclusion, that is, disposal from this apex court. This often leaves generations of litigants hanging in an almost perpetually liminal state. Additionally, it disproportionately affects underprivileged by discouraging them from seeking judicial enforcement of their legal rights. To further improve the efficiency, I once again call upon this court to employ modern tools of information systems and technologies. This court has already successfully employed video conferencing facilities to ease the burden on litigants and advocates. The court must also rely on artificial intelligence tools to not only perform its judicial tasks more expediently, but also enhance its administrative capacity. AI can help identify and address bottlenecks in our judicial system. Further, an important lesson that merits mention is the avoidance of politically charged matters. Every second that the court spends entangled in politically charged litigation is precious time that could be used to resolve decades-old cases involving ordinary litigants, the ultimate consumers of our justice system. Entanglement with political questions not only burdens this court's resources, but also results in unnecessary controversy around this court. This is neither in the interest of this institution nor the ordinary litigant. I conclude my speech with the hope that this court will continue to show exemplary judicial leadership and build upon the momentum from last year to make further inroads into the challenges we face on the judicial front.